Welcome, everybody, to another one of our interviews for the Divorce Magazine. If you have not been to the Divorce Magazine website or the YouTube channel, please go there. There's so much information that we get from a lot of divorce professionals. We only accept articles and interviews from divorce professionals. Like today, we have Judith, except if somebody is writing from their own perspective. So this morning, we are really happy to have Judith Buckland, who's a solicitor with Woolley Co. Woolley Co are one of our first contributors on the Divorce Magazine way back in 2013. We had an article from Andrew Woolley, and we still continue to have, contributions from Woolley Co. So do visit and see what they have to say about divorce. So Judith Buckland is based in Cornwall. She has over 20 years experience of family law, all aspects of family law. Legal 500 has named Judith as one of their recommended lawyers, and this has been for family law in Southwest, and this has been going on over several years, this recommendation. They note that she comes highly recommended as part of their team that provides a knowledgeable and conciliatory approach to all family matters. Judith has a particular interest and expertise in financial issues arising from family breakdown and has a good reputation for acting for grandparents in disputes relating to contact with their grandchildren. So if you're in that situation, please don't hesitate to get in touch with Judith. Since joining Woolley Co, she has dealt with many cases for British experts and cases where there is a question about the international jurisdiction, which international jurisdiction may apply when it comes to divorce proceedings. So thank you so much, Judy, and welcome to the Divorce Magazine Expert Interviews. So today with Judith, we'll be looking at three different aspects. We'll be looking at dividing assets, we'll be looking at child support, and we'll be looking at financial planning. So we'll start with dividing assets. And shall I go ahead with the first question?
Yes, please do.
Okay. So what are considered assets in divorce?
Everything, basically. So anything that either of you own jointly or solely is an asset. And there's obvious things like savings and stocks and shares and property and pensions, but it can be other things as well. It can be things like artworks or furniture, antiques, anything that's got a value is considered within divorce proceedings.
Okay. Including pensions.
Including pensions, very importantly, yes.
Yeah. Okay. And what advice would you give a couple at the start of their divorce in terms of asset division? So they come to see you and they're like, what do we need to keep in mind? Or she or he comes to see you, or they.
Well, I think one of the first things that I say to people is, look, we've got to build up a picture of what you have both got. So I kind of start going through them with a list so that we can go through some of these things. And that kind of helps as a bit of an aide memoir. I can prompt them on certain things that they might have got. And you'd be amazed how many things they kind of go, oh, yes, I do have this and I do have that. And oh, gosh, I hadn't thought about that. So it's quite helpful to be quite focused about what you think is something that might be an asset and to discuss that with your lawyer, because things get left out sometimes. We only kind of find them at a later stage. So I think that's an important thing. And just to be kind of quite clear about what you both want to include, keep the communication going between the two of you, see if you can make it into a bit of a joint exercise to do that. Because any lawyer is going to tell either of the parties, we can't even begin to kind of start putting this apart until we know what's in the pot. Right. I think that's an important point, and it's a bit of homework that the client can do from the start, take a bit of control.
Okay. I like the fact that you said they do it together. I think that's quite encouraging instead of, yeah.
Sometimes it's a bit naive to think that can happen, and you've got to keep that in mind. But, again, the more that they can talk, the easier it's going to become for somebody like us in the courts to sort it out. And again, I think don't have too high expectations of yourself, because you inevitably are going to disagree. It's an emotive subject with anybody, let alone people who are, their lives are kind of falling about around them. And just kind of say, okay, what can we agree on? And let's just leave to one side the stuff that is difficult or acrimonious, because you're not going to get anywhere by just trying to beat the other one down and get them around to your point of view. So let's just see what we can agree on, even if that is just how much do you think the house is worth? Well, I think it's worth 500. Well, I think it's worth 700. Well, what should we do about that? Should we maybe go and speak to some agents and see if we can find out a little bit more, rather than just a constructive sort of conversation? Because that's really helpful. It's helpful for both of them. It empowers them, and it makes our job a lot easier.
Can I just ask also, because inevitably they will have to sit down at some point and talk about those assets. So it's not like you can ignore that, whether you agree at that moment, but you will have to sit down at some point and talk about the assets that are. You mentioned, Judith, that some things tend to be left out. What kind of things do people not think about, which are actually...
People forget what I mean, you think they've got, 7 bank accounts and they forget. They think they've only got 3. I mean, I have to say I hold my hands up on this one because I'm not sure that I could actually say, definitively what accounts I've got. And then they come out of the woodwork at a later date. Not because somebody is trying to hide that away. It's just that some people just don't have a handle on their finances, and people find it a difficult exercise. I mean, lots of people are very, very in control of their finances, but equally as many people just really haven't got a clue what's going on because maybe they're not the one who's dealt with finances, and so things do get left out. Pensions, I mean, you've mentioned this already, it's an absolute classic. They're often the biggest asset that we're dealing with in a divorce, but so many people just kind of think, oh yeah, I suppose we have got pensions as well, because it's just too much in the future and too kind of, it's not a definitive asset, it's just not a liquid asset. It isn't like you can go and get it out of the bank and spend it. So they don't really think about it. So that's something you quite gently have to bring them into thinking about and looking at it and saying, yeah, this very definitely is an asset and we need to think about how we're going to sort this out.
Yeah, okay. Are there any assets in divorce that cannot be split?
I thought about this, and I think the answer to that probably is no. Pets. That's a good one. I mean, I say it jokingly, but actually it is often a very, very sought after because, family pets are more than just an asset, but the court will look at them as an asset. So they will say, well, how much is the dog worth? Not who's going to have the dog. So that's an interesting one, albeit it's a bit of a kind of side issue. But I think the one thing that causes difficulties asset-wise is interest in particular family businesses, and farming is the one I'm thinking of. Because you very frequently in that situation got a farm that's owned between several different people, usually in the same family. It very much is an asset, but how do you actually realise that without absolutely destroying the farm or the business? So that's a tricky one. It is an asset. We do have to factor it in, but how we factor it in can be quite difficult.
Okay. Can I just ask about inheritance? So let's say your partner inherits something from their parent or a relative, and it's stipulated in the will that this is just for Judith Buckland, not for the Buckland family. This is for you. Can that be respected, or does it fall into the matrimonial pot?
There's no straight answer to that, no simple answer to that. I think if you push me, I would say that the likelihood is that it will fall into the matrimonial pot. If it was inherited during the course of the marriage, and if it's a relatively long marriage, mid-term relatively long marriage, I think it would be very difficult for somebody to argue that that was a non-matrimonial asset and should not be shared, irrespective of any stipulation in, say, it was a parent's will. I think the thing to do in that situation, if that is an issue and the people who are leaving it to the one party feel strongly about that, then you're into the realms of getting some sort of agreement drawn up between the husband and wife at that time, which says this is to be ring-fenced in the event of any divorce. So really what you're talking about is a post-nuptial settlement, I suppose. So a settlement reached during the course of the marriage about a specific asset. So I think that's the advice I would give in that situation. But if it is just a lump sum of money or capital that has been inherited during the course of the marriage, it will go into the pot. I mean, that is a bit of a sweeping generalisation because it can depend. I mean, for instance, if you were married for 2 years and the inheritance came in maybe right at the end of the marriage, then the question is this a matrimonial asset or not? And that's a question to be looked at. The difficulty with, or the beauty with, and the difficulty with matrimonial law is that kind of the element of discretion is enormous. So there's no nice, neat little answer which says in this situation this happens and in that situation that happens. We've got to look at it on an individual basis.
Yeah. Okay. And is the division of assets dependent on child arrangement order?
I would say no.
Vice versa.
I'm not sure I would have said that 10 years ago because I think it has changed in as that I suppose when I first started in this profession, if, let's say, a mother was going to have, most of the children was going to spend most of the time with the mother, then I think the mother would say, well, look, my needs for housing is greater than that of father because I am the primary carer of these children. I think that's very much fallen out of favour now because courts will view this and say, well, look, you both need a home for the children. It's as simple as that. It doesn't matter whether the children spend 2 days a week with dad and 5 days a week with mum, or even, the weekend a month with dad and the rest of the time with mum. They both need a house that's suitable to provide a home for these children. And so your housing needs, husband and wife, are exactly the same. And I'm not really terribly interested in one of you saying, well, I need a 4-bedroom property because I've got 3 children. He can go and live in a 1-bedroom flat. They're not going to swallow that one down. So I think I would say that that definitely is the attitude of the courts with regard to meeting housing needs where there are children. There are exceptions, and it tends to be where children have greater needs. So, for instance, if you've got children with health issues, then it may be that there's extra capital needed for the person who's got the primary care of that child. I don't know, or converting houses or facilities and that sort of thing. But certainly with adult children who've got other physical or mental difficulties, that certainly is a factor that the court will look at and take into consideration. But as a general rule, no, I don't think the child arrangements make a massive difference to the sorting out of the financial issues.
Okay. And what about mediation? I trained as a mediator many years ago and I practiced for a little bit. The question that I have in mind is, can the division of assets be agreed in mediation?
Absolutely.
And if
Absolutely.
so, if so, is it legally binding?
I mean, the whole point, you'll know this yourself if you've been a mediator, the whole point of mediation is it takes place without prejudice. So that it has to, because otherwise, how can you have a frank and sensible session with a mediator to discuss things without the fear of getting it wrong or being held to something you say? You haven't got your lawyers on board, your mediators aren't lawyers, or if they are, they've got their lawyers' hats on, that's not their role. So, it can be quite an intimidating experience, I think. And I've got a lot of clients who will ring me kind of before the mediation, during the mediation, after the mediation, saying, what's wrong? No, that's the whole point, is to generate a frank and sensible discussion. And so what we often will find is that, yes, an agreement can be reached, and the mediators will prepare us a memorandum setting out that agreement. Clients come back to us and say, what do you think? And we then give advice as lawyers. Sometimes that advice can be seems very sensible, and they don't think there'll be a problem with that. Sometimes that advice can be, well, what about this? And have you thought about this? And we may then kind of tweak that agreement in some shape or form. But no, it's not binding. It's not binding until it has been made into a court order. So once the mediation agreement has been reached, come to the lawyers, the orders are drawn up and approved by both parties, and we submit them to the court. Once the court has approved them, that's when they become binding.
Okay. I'm going to throw in a question that
Go on then.
which you mentioned something earlier on, but it was more around post-nups. And now I'm thinking about the mediation, but now I'm thinking about prenups in the UK. If you do have a prenup, is it respected when it comes to divorce proceedings?
It can be, yes. Again, this is an answer that would have been very different many years ago, because we're one of the countries who have been dragged kicking and screaming to prenups, but now they do carry an awful lot more weight. And the thing that we would always say is that yes, absolutely get a prenup. Make sure that you are both legally represented. Make sure that you do it well before the wedding, and make sure that you have provided full financial disclosure of your circumstances, ideally documented and attached to the prenup agreement. And if you do that, then you've got a far better chance of that being respected by a court in subsequent divorce proceedings. Although I would say, obviously things change, so you could have a prenup drawn up, and 5 years down the line there could be children involved, and those children's needs are always going to trump what is said in the prenup. I mean, if you're sensible, you get the prenup to kind of look to be reviewed every now and again, and particularly on major events. So they are certainly being upheld as long as they are drawn up properly and they meet the needs of any children subsequent to the obviously the prenup, and indeed the needs of the parties.
Okay. And is it fair for me to say that even though you have a prenup, it doesn't mean that there will be no issue with division of assets, because you might each have a prenup, but then you go and buy a house.
Exactly. So prenup is really dealing with pre-acquired or pre-held wealth, and that's often where we do them. It happens a lot in second marriages. So if you've got people who are in their 50s or 60s, maybe getting married again, they've got quite a lot of assets behind them. They may have children as well who they would want to leave them to. They want to make sure that those are preserved. But anything that's subsequently acquired, then, as you say, falls into the matrimonial pot and could be part of a disagreement about how that's going to be dealt with. So it doesn't necessarily, it's not a silver bullet.
Yeah. Okay. Yeah. Okay. Thank you so much for that, Judith. So I have some questions around child support. How does the court decide who pays the child support?
The court doesn't.
Ah.
The court has no jurisdiction over child support, other than in very limited circumstances. So if there is a dispute over how much child support should be paid, the only organisation who's going to be able to deal with that is the child support agent, sorry, the child maintenance service. So you would have to make, either party can make an application to the child maintenance service to have the other party's income assessed as to how much they should be paying by way of child support. The court can and do record any agreements with regard to child maintenance. So if, for instance, it's been agreed that £300 should be paid a month, that can be recorded in a financial order dealing with the other matters, and it will hold good for 12 months. So the other party can rely on it if you enforce through the court. But after 12 months, it effectively lapses, and the child maintenance service then comes back into the play. You would have to make any application like child maintenance service. Okay. The areas where the court can and do get involved in child maintenance are when when one of the parties is living abroad, so the child maintenance service doesn't have jurisdiction there, where the paying party's income is beyond the upper limit of the child maintenance service. So there can be a top-up order if it's a particularly wealthy paying husband or wife, and where the child has special needs, mental health issues, or not mental health issues so much as it tends to be physical difficulties, disabilities, that sort of thing. And school fees, which also falls under child maintenance as well. So the court can make orders about who pays school fees. So their remit is quite limited.
Okay. Do parents have to go to court for this decision to be reached?
No, they don't have to. So from the point of view of, obviously, if they're in agreement about how much child maintenance and they're just recording it, as I just said, they're in agreement. And if they're in agreement, then you may find that it can be dealt with by consent. It can be dealt with in a written exercise. So an order is drawn up reflecting the agreement. It's then submitted to the court to be dealt with in a paper exercise. Yeah. But then if you're looking at things like school fees or top up, or where parties are abroad, yeah, you can end up in court arguing about that. We would always aim to try and reach an agreement. Okay. The golden rule is to try and keep it out of court and settle as much as possible without getting people involved in as court as possible. But with the best will in the world, parties don't agree, and somebody has to make a decision. Okay. What if a parent fails to pay child support? Well, that would then be enforced by the child maintenance service. So okay. I don't profess to understand fully the kind of whys and wherefores of the child maintenance service. We tend to, because it's not court-based, we tend to refer clients on to other organisations to deal with disputes about that. But in effect, what they will do is they will collect that money from the person's income. So if they're employed, it's relatively easy to do. If they're self-employed, it's more difficult. But yes, that's how the child maintenance service will deal with it. And as far as the courts are concerned, if it's not paid under the court, then the normal enforcement procedures can be applied for non-payment. So there's various options that can be used there, which is quite effective to get the money out of the non-paid party. Okay. For those who are just starting off, or they're just trying to figure out the child support, can you tell us a little bit about what the child maintenance service is? Yes, well, it's a government organisation that was set up to deal with this problem, to assess maintenance. I've actually been practicing long enough as to remember when the courts used to deal with all of it. So I can remember when the CSA came into operation and this, that, and the other. And it effectively just took it away completely from the court. As you say, it's a government organisation. They're quite formulaic in the way that they assess child maintenance. You make an application to them, and they will go through the figures and come up with a figure. And what I spend quite a lot of my time doing with clients, because there's no need for the CMS to get involved, it can be agreed between the parties. Best advice I think that I can give to anybody, and I use it myself, is that they have got a great calculator on their website. The CMS website have got this very, very easy to use, straightforward calculator where you can put your figures in and they will come up with an assessment of what your income might be. It's a bit rough and ready, obviously, it's not very sophisticated, but it's a really, really good guidance. And if you sit down and talk to clients, whether they're the paying party or whether they're the party who's on the receiving end, and say, look, this is kind of the figure they're looking at with the CMS calculator. Use that on the basis of your discussions, and it may be that you can come up with some sort of agreement as to how much you should be receiving or paying. And that works quite well because it's something that both parties can use. That kind of takes away the subjectivity of it. And we usually find that we can reach an agreement there. Inevitably, some parties don't. Inevitably, some parties are trying to avoid paying, and that's all that's it.
It's really good to know about that child maintenance service calculator, because then it gives you an indication. I didn't know about the, I remember when it was CSA and then they changed, but I didn't know that they had the.
No, it's very obvious. You just go on their website, the CMS's website, and it will say there right at the top, actually, do you want to use the calculator? And it's just a case of putting in your gross income, how many children they are, how much time they spend with you, because that will make a difference. If children spend more time with one parent, the child maintenance calculation will go down, or for instance, the parent might have other children who are dependent on them, that makes an impact as well. So it is a very, very handy tool.
Okay. And is it automatic that whoever earns more will pay the child maintenance?
It doesn't matter how much they earn, it will be assessed on what their income is. So it doesn't matter if they're earning more than the party who's spending most time with the children or less. It will be assessed on whatever your gross income is.
Okay. And just like if anyone is just listening to this section of the interview on child support, I'll ask you a similar question that I did with a division of assets, which is to do with mediation. So we go for mediation and we agree this is how much this person's going to pay for this, for the child maintenance. Is that legally binding?
Within mediation? No, it's not. Nothing in mediation is binding. It is completely any discussions are without prejudice, which means they can't be used as evidence of a binding agreement.
Yeah.
So your discussions within mediation are very free, so that you can try and see if you can reach an agreement. It is only when it is put into a court order that it then becomes binding and enforceable.
Okay. All right. That's so important because I remember that's one of the questions that we used to get even way back when I did my.
Oh, absolutely. And it's one of the things that my clients are concerned about. And when they ring me up, they've just been to mediation. I think I'm actually saying something stupid and I'm in difficulties. No, you're not in difficulties. Nothing is stupid. Get everything out. Use that opportunity of mediation to ask any question. No question is too stupid. No suggestion is stupid. Let's just explore every option. Because that's how you move forward and reach agreement. And that's what it's about. Trying to find a solution that works for everybody. So
that's child support and division of assets that we have covered. So now we're going into the financial planning section of the interview. And so what is financial planning and how does it fit in with the divorce process?
I suppose financial planning is having a think about the impact of what you are trying or what the division of the assets is going to be. And it's really important to think about that right from the start, because you are taking one family and one financial unit and you're dividing it into two. And that's going to have a massive, potentially have a massive impact on how you manage your finances moving forward. And that could be something as obvious as, okay, well, how am I going to buy a house? I've only got me as a mortgage, potentially as somebody who can apply for a mortgage, not me and my husband or me and my wife. So that's inevitably going to have an impact on how much or how little I can get by way of mortgage. So get some mortgage advice right from the start, I would say. It's a bit of homework I give to new clients, which is go and see a mortgage advisor. Ask them, give them your kind of circumstance, and then ask them not only how much you might be able to get, but what the terms of that mortgage are. Because it's all very well a mortgage advisor saying, yes, I can get you a mortgage of 200,000. But if that's going to not enable you to sleep at night because you're trying to find the premiums, it's hopeless. So get some information so that you start then thinking realistically about what your options are. And that could also be in relation to, say, for instance, if we've got capital to divide, how can I make that capital work best for me? Is it best to pay off maybe an existing mortgage? Is it best to put it into a pension policy? Is it best to invest it in this, that, and the other? You don't know. I certainly don't know because I'm a lawyer. I'm not a financial advisor. So you need to go to I would always say an independent financial advisor and a financial advisor who is specialising in that particular area. You can go to a generic financial advisor, but there may be something very specific you want to talk about, whether it's a mortgage, whether it's a pension, whether it's investment. Because sometimes we're getting quite big capital sums for clients, and it could just sit in an account and do nothing, but it could work for them. And they're not going to know that, and I'm not going to know that. So go and talk to somebody. And for instance, as well, if we are, as far as pensions are concerned, we can possibly split pensions away and pay them into that person's existing pension policy. Or they may want to set up a new pension. I don't know which is the best option, but somebody does. You go and speak to a pension advisor. Yeah. Or they may have capital which they don't know what to do with it. I think I said this already, which is what's the best way of making that capital work for me? What's the best way? Is it potentially to invest it into a pension so that in 10, 20, 30 years time I will have an income? Because I can manage this at the moment, but I've got to think about things in the future. And it's difficult to do. I think, we're expecting people to make momentous financial decisions at the time of life when they're probably least equipped to do so because they're going through such a difficult time. So the more help you can get, the more advice you can take from people. You can feel free to ignore that advice, but at least it enables you to have the knowledge to make those decisions. So yeah, absolutely. Take some financial advice throughout. Right at the beginning helps to concentrate your mind on what's important, and throughout.
Yeah. And I'm thinking about, when you're talking about the financial planning, especially around mortgages. And I'm thinking about the people who are aged, let's say 50 plus, who now need to go and buy somewhere else. And because, the age, the length of time, the mortgages that are out there for people over a certain age, it becomes more tricky compared to if you're in your 30s and, they see like you have forever to work.
Yes.
Yeah,
exactly. It absolutely does. And I've got people who are in their 50s and 60s and thinking, well, how is this actually going to work? Actually, a more positive thing to say about that is people often come to me and say, well, you're about 53 and I'm never going to get another mortgage. Yes, you probably are. Go and talk to somebody, because what has happened over the last however many years is that the mortgages have extended. People are happy to give mortgages up, certainly up to retirement age, and often to well beyond. And this is not just specialist mortgages, this is pretty standard stuff. So go and talk to somebody about what it's involved. And that goes back to the point that you made, which is you need to get equipped with the information to enable you to make the decisions.
Yeah.
So I can think of a client I had who there was a lot of capital sloshing around. But she just wanted her house paid off, and she wasn't interested in anything to do with her husband's very handsome pension, thank you very much. And it wasn't until I said, look, go and talk to a pension advisor, go and talk to this, that, and the other, that she came back to me and said, yeah, actually, you're right. I think you probably do need that. And it's just kind of, getting your head around that. Sometimes you haven't needed to think about that at all during your life. So you may not be particularly financially savvy or even particularly aware of what's going on. So just going and talking to somebody and realizing the pitfalls and the fact that you can do something about it, maybe, not always, but maybe, it just gives people, knowledge, and that enables us to then move forward and try and find the best solution there.
Yeah, and make an informed decision.
Informed decisions, absolutely. Free to make silly decisions, but informed silly decisions are fine. Uninformed, if silly decisions are really not.
Yeah, I know I've fallen in the trap or into the trap of making uninformed when it came to divorce and
I think
financial.
we all have. I
Yeah.
think we all have, yes.
Do finances need to be sorted out before a divorce can be granted?
No, in fact, they frequently aren't. The way that divorce works is that you start the divorce process with the new divorce procedure that's been in for a couple of years. There is a 20-week sort of hiatus in between starting the matter off and being able to finalise it. And our advice is always the same in those situations, which is, okay, let's use those 20 weeks and we might be able to sort things out within those 20 weeks. Very frequently, we're not able to. So we get to that 20-week period and parties are saying, well, do we apply to finalise our divorce now? And my advice is inevitably, no, don't do so, because all sorts of pitfalls can follow. And in the main, it's to do with people pre-suiting, sorting out the finances. So, for instance, if you bring your marriage to an end, you are no longer a wife or a husband, and therefore you will not benefit, for example, on any widow or widower's benefit under a pension if that person dies. You will not automatically inherit their money if they die intestate because you are no longer a spouse. You will not qualify for the exemption on inheritance tax. If they die, because there is no inheritance tax payable between husband and wife. And there are things like kind of life policies, that sort of thing, which sometimes can be dependent on spouses. And so all of those potentially could cause a massive financial loss to somebody if, God forbid, one of the parties died before we were able to sort out the finances, get a financial order. So leave the divorce, put that on the back burner. Let's concentrate on sorting out and getting our final order for divorce. And once we've got that, then we can apply to finalise the divorce, which is actually a very straightforward application to know. But usually, 9 times out of 10, it's not going to cause you problems. But it does happen. I've seen it happen, and I've seen the financial losses go to the schools. So, the advice to us saying, please do not finalise your divorce at this stage, because you could really, really impact financially negatively in the event of your spouse dying. The
last question, if I could just merge division of assets and financial planning and probably put, child support in between there somewhere.
Yes.
How can I tell if my spouse is being completely honest about their finances? Can I tell?
Well, you've probably got a bit of a gut reaction. You probably know that there might potentially be a bit of a problem. But I think within the gathering of the financial information, financial disclosure, it becomes usually pretty obvious because the financial disclosure that we advise clients to obtain is quite comprehensive. So we are looking for not only lists of what they've got, we want it backed up with evidence. And if you get a feeling that something is not actually being disclosed to you, you're going to ask for more. And a paper trail shows all sorts of things. I mean, if you say routinely, if we're in court proceedings, the court will routinely say, I want not only a list of all your bank accounts, I want 12 months bank statements. You would not believe how illuminating bank statements can be because you can spot anomalies. And so usually we can see from a combination of looking at the paperwork that we've got and certainly asking questions, because we spend quite a lot of time saying, okay, what about this? 9 times out of 10, there's a perfectly innocent answer. Sometimes there's not. And it just doesn't add up. And that's where you start to think, okay, there may be stuff there that isn't being disclosed, or there may be stuff that's trying to be hidden. All the sort of tricks of the trade that we see time and time again. So properties, for instance, we're not disclosing those. Well, why are we not disclosing those? Because we know we've got 2 investment flats in Birmingham or whatever. Could I've transferred it into my brother's name? There's a paper trail. We usually find it. And that's what makes costs up. So if people are not going to be transparent and honest with their disclosure, that's when the problems arise, because we often need the court's powers to be able to order them to provide information. I can ask and they can ignore me to enter in the face. So there's this line to be drawn between involving the court or trying to avoid involving the court, and knowing that you're going to need to in order to have the power to get that information. To make sure that it goes back to the point I made right at the start, which is we need to know what's in the pot before we can start working out what's there. And if one of you is not providing that information, we don't have a full picture of what's in the pot. So we need to do that exercise.
Yeah, in a weird sort of way, it's like if you're not being honest because you're trying to hold on to your money, you're actually taking that money and giving it away because
you're giving it to the lawyers, quite frankly.
Yeah.
And that's what I say to the clients, which is, you
Yeah.
know,
just be
there is
honest.
absolutely no point in being not being straight. Number one, it puts me in a difficult position. I can't act on somebody being straight. But you're just going to exacerbate the problem. You know, we can either do this the easy way or we can do it the hard way. And if you're going to make it hard, costs are going to go up through the roof. Potentially, you could be penalised on costs because you're being dishonest. So that's going to impact on you. Just taking away from the pot that we're trying to sort out. So cards on the table. Let's be really. I know it's difficult, and as I said, I think previously, it is an emotive subject. We're quite protective of our money, and we're even more protective of our money if we're going through separation and divorce. But get it out there, get the information out there, and then we can start looking at what's there. But there are all sorts of things that we can do if somebody is being somewhat less than honest about their disclosure. But it doesn't always happen.
Thank you so much, Judith. It was a really, really informative and interesting interview. So many questions were still floating in my mind, but I know we can't cover everything right now. But one of the things that you've made me think about is having an interview, because you kind of pulled out a little bit about the mediation side of things and the power of mediation and what it entails and what it might look like. And I think a lot of people need clarification as to what that is about.
I agree. I mean, I quite frankly, I don't know what mediation is. Never been to a mediation. We always don't go to mediation, so we don't know kind of how it goes, other than just through talking to mediators anecdotally, I suppose. But I think you're right. I think there's a lot of fear around it.
Yeah.
A lot of clients will come to me and say, well, what does it involve? And I can kind of answer that in some shape or form. But
Yes.
A, it's going to be different, and B, I've never been through it myself.
Yeah.
So what I think I said this, what I quite frequently do is, yesterday I had a long chat with a chap who was going to mediation, very, very concerned about it. And we just covered about what might involve, what might happen, what might not happen. And then I quite often get them ringing me during mediation. So who's doing what? And it's really helpful. If I know when they're going to mediation, I block it out of my diary so that I'm free for a telephone call if they want to just have a 3-minute conversation with me whilst they take a break in mediation. So, I think it's something that we can offer quite a lot of support in and empower them a bit. And that in turn is going to make it much more likely that mediation works.
It sounds like, is it then fair to say that mediation and having a solicitor can actually be quite a good team, a good process to go through? Yeah.
I've always thought that. I've always thought, to have kind of mediators and lawyers, they are different roles. Of course they are. And I think you can't kind of, I'm not an agreement. I think people have suggested that you have have lawyers in mediations. I'm not sure that that's possible. But I think just supporting your client and offering that service to your client about mediation, and just answering a few questions, and just reassuring them. It's reassurance that they often want, and can be quite constructive, I think.
Yeah. Thank you once again, Judith. Really informative. Now we know we know more about financial planning, child arrangement, and the division of assets. All three areas that kind of, in some form or the other, they come in, through any divorce process, whether amicable one or one that is very conflictual. Either way.
Yeah, they're the same issues that need to be looked at. You need to, try and get it as right as. You need to try and get it right for everybody, and you've got to think about all those elements.
Yeah.
So there are parties who come in and often say to you, "Oh, we're going to do about the house," and you think, "Well, what else have you got?" And they don't really want to talk about that, but you've got to look at it holistically. It's not a case of, well, let's sort out the house, let's sort out the car, let's sort out the dog, let's sort out the pension. No. Let's look at the whole lot, because there is more than one way of skinning a cat, and it still stuns me after the number of years that I've been doing this job that every single case is different. We've kind of got to approach it in a different way. And you come up with the solutions that work as best as possible.
Yeah. Okay. Thank you so much. Thank you so much for listening. Thank you for being here with the Divorce Magazine. I didn't say my name at the beginning. My name is Dr. Soila Sindio. I'm the founding editor of the Divorce Magazine. I hope you really enjoyed that. Go off to our website and YouTube channel and just see what we have there for you. Thank you so much, Judith. And if you're on YouTube, just like and subscribe, and we'll take it from there. Thank you so much. Take care.
Thank you. Bye-bye.
Bye.